All right, as soon as I know I've got a connection with everyone, we'll go on the record. Looks like we're having a little trouble with Mr. Ball. Mr. Ball, can you hear me now?
I can. Yes, sir.
Okay.
Yes, I can, sir.
This is the matter of the Ball minors. I'm sorry, Shannon, put us on the record. This is a matter of the Ball minors. Counsel, can I have each of you identify yourselves for the record?
Matt Way, Prosecutor's Office.
Rebecca McCluskey for Courtney Ball.
Ken Hotchkiss with Russ Ball.
Okay, Mr. Ball is present, and I've got Courtney's iPhone. I'm assuming that is the mother. Ma'am, can you hear me?
Yes, I can.
Okay. So I think everyone's been identified.
Your Honor, Mr. Brown is the guardian ad litem.
Oh, hold on. He just logged in. Okay, now Mr. Brown is present. So I understand as a preliminary matter, Mr. Hotchkiss, you have a motion.
That's correct, Your Honor. Without giving away any attorney-client privilege or putting Mr. Ball in any kind of jeopardy, based on what's occurred since I was appointed to represent Mr. Ball, I cannot adequately and appropriately represent him going further.
Let me stop you, Ken.
Yeah.
Whatever happened, we lost Ivan. Now I got to try again.
Okay.
And looks like a police officer is present. We'll leave him there for now. Okay, Mr. Brown.
Yes.
Okay, great. Looks like we had a little trouble getting you in. So I'm sorry, Mr. Hotchkiss, I interrupted you. Go ahead.
Sure, thank you. Your Honor, based upon what's occurred between myself and Mr. Ball since I was appointed to represent him, it would not be appropriate for me to continue my representation of him. I won't go into what has occurred. Certainly, Mr. Ball still enjoys attorney-client privilege with myself, but given what has occurred, it will be impossible for me to adequately and appropriately represent him. I would ask that the court release me from representing him, and then I can leave it to him how he wishes to proceed. Thank you.
Is there any objection to Mr. Hotchkiss's withdrawal as Mr. Ball's counsel?
No, Your Honor.
No, Your Honor.
No.
Okay, Mr. Hotchkiss, I will grant your motion and relieve you of any further legal obligation towards Mr. Ball. So, Mr. Ball, we are scheduled for trial. You are entitled to be represented by counsel, but clearly Mr. Hotchkiss is not going to be able to represent you. What is your desire today?
I do need counsel, and all I asked was I would like more time to prepare than 2 days. I have not spoken to my lawyer about any of the case. I do not have any paperwork, so he wasn't representing me anyway. So that's what the conversation was, and I told him that I wanted above and beyond because these are my kids, or he could just quit, and he's choosing to quit. I needed him to talk to the school. I need to do all these things, and he didn't want to hear any of that, and he doesn't want to help me. So I need a lawyer that's going to help me. This is my life. These are my children. If it seems like I'm being loud, that's just my voice. They keep picking with me about my voice, of how it carries. I have a deep voice, sir. I'm not trying to be loud. I'm not upset. That's what I mean. It's like I'm being prosecuted for charges that I've already been prosecuted and done with my time. It's like a personal thing right now. I feel like, no one is trying to help me. I have recordings of asking these people for help. The supervisor, Margaret, all these people, I've asked them for help. No one is helping me do anything. Unfortunately, the day that you kicked me out of my house last time, the house caught on fire, and I wasn't able to even be there to help my children. No one has called to help my kids. No one has done anything for my family. To me, with all due respect,
Mr.
Your Honor,
Ball, I'm going to stop you. I'm going to stop
sir.
you.
Yes, sir.
You've indicated that you'd like to have the court appoint someone else to represent you.
yes,
We
sir.
will try. Has Mr. Kelly been involved in this case?
It was my understanding from an email that you wanted Tim to participate.
I
Mr.
asked
Kel-
for other attorneys to be here so that it might be possible to appoint someone today and at least begin some dialogue between attorney and client. If I have to wait for another day to identify an attorney, it's just that much longer before he can get up to speed.
Your Honor,
Um,
Mr. Kelly indicated that he had a conflict from a prior, I believe, a custody case, so that he wouldn't be able to represent Mr. Ball.
All right, that frankly only leaves Mr. Williams. He's not present here today. Mr. Ball, have you ever met or had any dealings with Mr. Timothy Williams?
No, sir, not at all.
All right, I will grant your request. We'll appoint Mr. Williams.
Thank you, sir.
We're gonna have to give Mr. Williams some time to get up to speed. So I had hoped he would be here today. Let me just verify. Is the phone number listed on the complaint your telephone number? Ends
Yes,
in
sir.
1148?
Yes, sir.
All right, well, Shannon, let's get this petition to Tim. Give him a chance to contact Mr. Ball. I will grant an adjournment today. Let's schedule the trial in 2 weeks. If Mr. Williams expresses that he needs additional time, I will be receptive to that.
You're not here in 2 weeks.
See, I'm gone in 2 weeks, so let's make that 3 weeks. That gives them an extra week to proceed.
February 2nd at 1?
Thank you, Your Honor.
That'll be February 2nd at 1 o'clock.
Thank you, Your Honor.
You're welcome. All right, looks like we are all connected. I want to call the matter of the Ball miners. I'm sorry, Shannon, put us on the record.
Okay.
I'm calling the matter of Reagan Cash, Gia, and Madden Ball. Excuse me. So let's see. Is Mr. Ball the only respondent?
No, Your Honor, the mother was made a respondent by, I believe, the first amended petition, and there has been a amended petition that was just filed, I believe, Friday, that I did provide to the parties.
All right, I just want to get all the players down. I usually write it on the jacket. I didn't this time. Who represents Mom?
Ms. McCluskey does.
I do, Your Honor.
Mr. Brown's LGAL?
Yes, Your Honor.
Okay, and for the moment, Mr. Williams, you are representing Dad, is that correct?
That's correct, Your Honor. Very eloquently said.
Okay, and Mr. Ball is present. Sir, do you pronounce your first name Russ or
It's Rouse.
Rouse?
It's pronounced
Okay.
Rouse. Yes.
All right, I want to make sure. I heard it pronounced otherwise, and I wanted to make sure when I used it, I pronounced it correctly.
Thank you. Thank you.
Okay, and let's see. We have.
Is there, could I address the court?
Yeah, oh, yeah, hold on. I have some preliminary stuff to get out of the way first.
Yes, sir. I just spilled my tomato soup. Dang it.
So let's see. well, I'm not, who is here on behalf of the agency?
Ms. Parks.
Margaret Parks, okay. And let's see. Is the mother present?
Yes, I'm here.
Okay, you're the one that says Courtney's iPhone. All right. Okay, I think we've got everybody then identified for the record. First order of business, did everyone receive a copy of the amended petition?
Yes.
Yes, Your Honor.
All right, and Mr. Ball, I understand that you and Mr. Williams are having some difficulty working together. Mr. Williams, do you wish to make a motion today?
Your Honor, yes, I think for Mr. Ball's best interest, he needs someone that he can have confidence in. I've tried, but him and I just can't communicate, effectively work together. So I would make a motion to withdraw as his counsel.
Is there any objection to Mr. Williams' withdrawal as counsel for Mr. Ball?
No, Your
Well,
Honor.
can I? Oh, do I
Yeah,
address
you
the
can
court?
speak.
Okay.
You,
I on the account of the lawyer situation, both lawyers have now quit on me because I want them to give audio and video of the treatment that me and my family's been receiving since this whole ordeal started. And so I was, he can definitely step down as I have it on recording. He hung up on me and quit on me because I want you to have certain evidence. I told him that I told both of these lawyers, I mean, there was a 2-day business days before a trial, and then this Mr. Williams wants to wait till 4 days before trial. None of them asked me for evidence. None of them asked me for character witnesses. None of them have talked to the middle school at Northwest Middle School. And I want to know how I'm a danger to my kids, and I've never had services or treatment plans. I've never, but I'm painted as a dysfunctional, inappropriate parent to children that have not identified or disclosed neglect or abuse. My children have never been observed with marks, bruises, injuries. They have not disclosed witnessing any violence between me and my wife. So I'm wondering, where's the neglect? Where's the, so these are the kind of questions I've been asking and I've gotten no answers. They tell me, read the petition. Nobody's even explained the petition. I don't even know what I'm going to court for. What, they're telling me there's stuff on 5 and 6 of the new petition that Farah, the supervisor, said you guys are coming into court today to take off of the petition. So like I'm being told lies. I have everybody on recording, lying to me, threatening me.
Mr. Ball,
Yes, sir.
Mr. Ball, let me address your concerns. So I've appointed 2 different counsel. Both have reported an inability to work with you. They're both competent. They practice regularly in my courtroom.
I have recordings, sir.
Let me finish, sir. Don't interrupt.
Oh, I'm sorry. I apologize.
Lawyers and clients occasionally disagree on the best manner in which to go forward. When that does happen and they disagree, what's left is you need to find another attorney. Okay. I've appointed 2 people. I don't have any more to appoint for you. If you want an attorney, you're going to have to go out and hire your own. I will give you time to do that.
I plan to. Okay, awesome.
Because there's been
Honor,
because there's been an amended petition filed, even if you weren't at odds with Mr. Williams, it wouldn't be reasonable for me to go forward with a trial today. So I am going to grant an adjournment. I want to give you ample time to find an attorney. I'm going to tell you, whoever that attorney is, you need to listen to. They understand the rules. They understand what works and what doesn't work. and you need to listen to them. If you want to do it your way, you certainly have the right to represent yourself, and I'll certainly give you that opportunity to do that. And I'm also going to give you an opportunity to find counsel. How much time do you think you would need?
I mean, at least 90 days, I think, to save
I-
enough money. Everybody I've spoken to wants $5,000 to $7,500.
Well, I can't give you 90 days. Mr.
Okay, well,
Wade,
as much as you can give me. As much as you can give me. I want a jury trial. I've not been given any of my rights. I've not been told anything about anything. I have evidence. I have witnesses. I have, I have it. I have recordings of Mr. Williams specifically quitting on me because what's the relevance of your tapes? Well, you haven't listened to him, so
right.
you gotta at least listen. So these are the
Ball,
obstacles I'm having. That's all. That's the obstacle.
Mr. Ball, I appreciate that they don't want to do the things the way you think you want them done. That's why you get to represent yourself if you want.
Okay,
you can
cool.
hire another
Yes,
attorney.
Okay.
So right. I'm going to mute you for
evidence.
now. Okay, so Mr. Way, I want to give Mr. Ball ample time to find an attorney if he can, or at least to prepare for himself if he's unable to find someone. But I'm wondering, do we really need to delay moving forward as to the mother? Is that something I can schedule relatively quickly?
I think we could schedule that one quicker. I would obviously defer to Ms. McCluskey. I do know, Your Honor, that Mr. Ball has spoken to Mr. Lyons because he reached out to me yesterday and we talked a little bit. I don't know if he'll hire him, but so it does seem like he's making an effort. I know from the agency's perspective, we want to, make some sort of progress on this case because we're kind of going backwards rather than forwards. And there's been a lot of communication regarding that. So I would like to get the attorneys together with the parents and the agency for like a family team meeting in the meantime. So I just want to put that on the record, and I will be reaching out to Mr. Brown and Ms. McCluskey so we can find a time because I think the agency is working really hard to keep these kids in home, but we're kind of at we're kind of at the end of our rope at this point, Your Honor.
Excuse me. Can I speak, Your Honor?
Sure, go ahead. You do have an attorney.
I
It's
do have an
probably best
attorney.
to speak through her.
I have spoke with her. I've spoke with plenty of people. I spoke with the kid's lawyer. I spoke with her. I spoke with Margaret. I spoke with Amber, and all of them have threatened me in every way that they are going to remove my kids from me. They're going to remove my kids from me if I don't do certain things. I feel threatened. They're banging on my door. I feel harassed. I've done nothing. I'm having to use my savings to go stay at hotels for reasons that are not okay. I've done nothing
Okay,
for my
ma'am,
children, and I've done nothing at all. I'm the
Ma'am,
victim,
I want
and I'm
you- I
getting
want
all
you-
kinds of threats, and I have recordings of all of that as well, even from my own.
Ma'am, I just muted you. I tried to interrupt, but you wouldn't let me. Let me make something real clear to you. If you don't comply with what the agency is requesting of you, I will remove your children from your home. And you could take that as a threat if you want. I don't care how you take it. I am telling you, you need to make sure you're doing what the agency is requesting of you to keep your children safe. If the agency comes to me with any further indication that you're not doing that you're not cooperating, that you're not engaging in what they're asking you to do to keep your children safe, I will remove them. That's what's going to happen. So if you want to take that as a threat, go ahead, take it as a threat. I don't care whether you think it's a threat. What I care about is that your children are kept safe. That's my
to hear it
paramount.
from you, sir. All I
That
want to do is
is-
hear it from you. I understand. I will comply. I wanted to hear it from you. I don't want them threatening that they're going to take my kids. I wanted to hear it from you that you tell me to go do this stuff, and I will do it. So thank you.
I'm telling you that, ma'am.
Thank you very much.
So let's set a new trial date in 2 weeks. How do we look on the, what is that, the
The
16th?
16th, we have absolutely nothing on our docket.
Great, let's set,
Right now.
let's set it for 1 o'clock on the 16th. Hopefully by then, Mr. Ball has been able to retain counsel. If not, I think we need to be prepared to move forward with the case. If there is continued lack of cooperation, I would encourage the agency to seek a removal order. It sounds like Mom at least is listening to me, and hopefully now she will listen to you. So we'll see you back here on the 16th at 1 o'clock, and be prepared to move forward with the trial. If Mr. Ball's counsel does in fact file an appearance and indicates that he needs a little more time, I will be receptive to that. Anything else I need to address today, counsel?
No, Your Honor.
No, Your Honor.
I don't believe so. Thank you, Your Honor.
Thank you, Your Honor.
Thank
All
you.
right, we'll move on to the next case. All right, it looks like everyone is here. Mr. Ball, you can hear me?
Yes, sir.
Okay, so Shannon, you could put us on the record now. Okay, this is the matter of the Ball minors. We have Mr. Way present on behalf of the petitioner, as well as Margaret Parks, Nicole Peters, and Amber Fader. Which of you, counsel, is LGAL?
I am, Your Honor, for Ivan Brown.
All right, and Ms. McCluskey, I'm assuming you represent Ms. Courtney Ball, correct?
That is correct. Correct, Your Honor.
Okay. Is there anything preliminary before I start taking testimony?
Could I
No, Your
address?
Honor.
Yes, Mr. Ball, go ahead.
So I was unable to get a lawyer, and I was hoping to get some kind of time. So obviously I'm gonna have to be my lawyer. I was hoping to get an adjournment for 2 weeks. I'm just waiting on, I've talked to JPD. I'm waiting on my police reports. I have medical reports that I'm waiting on. I have witnesses that I haven't been able to subpoena because I was unaware that I was gonna have to be my lawyer till Thursday. You have to excuse me, I'm kind of nervous. I will not waste any more of the court's time. I just need, if I could get 2 weeks to, I'm representing myself out of a vehicle, if you can see, and I just want to have a fair shot. I can't defend myself in a car. If you give me 2 weeks, I will be prepared. I will not ask for anything else. If I can't, I'm not sure, but I would, if not, I'd like to have an in-person hearing. I mean, I have evidence, I have pictures, I have all these things. That's why the lawyers quit. So I would like to be able to at least have the fairest hearing possible, sir.
All right, well, Mr. Ball, frankly, I am inclined to give you a couple more weeks, but let me hear from Mr. Way and Mr. Hurlbert and Ms. McCluskey before I give a final word on that. Mr. Way?
I certainly understand Mr. Ball's position. We are prepared to proceed today. I guess I don't know what has been provided to him, if anything, from his other attorneys. Given that he's going to represent himself, he certainly is entitled to receive the discovery that everyone else has received. And I don't know that he has probably received that, but that's something that I can email him. So I intended on, really wanting to push forward with this case, but I think in fairness to Mr. Ball, if he doesn't have everything, and then it's probably only fair to give him a couple of weeks.
Ms. McCluskey?
I understand that position. I have no objection to an adjournment. Thank you.
And Mr. Hurlbert?
Your Honor, I believe it's in the child's best interest to have a fair hearing, so no objection.
Shannon, how does our calendar look in 2 weeks?
You got the Lewis Eubanks Bradshaw termination trial.
I'm guessing there's a lot to that one. And that there might be I don't remember, there might be a jury demand. I'm guessing that case is probably not going to go on that day, Your Honor.
All right, well, let's go ahead and schedule this on that date. Mr. Ball, I do want to give you every opportunity to be fully prepared. And I realize it's a challenge doing it on your own without an attorney. But I'm going to grant your request. So we'll adjourn this for 2 weeks. And I'm sorry, what's that date again, Shannon?
March 2nd.
March 2nd, we'll start sharply at 1 o'clock, and hopefully I'll be back at the courthouse. I suspect we'll have all the snow cleared at least by then.
Could I just have Mr. Ball give, and maybe we go off YouTube for this, but have Mr. Ball give me his email address so I can forward everything that would be considered discovery to him.
All right, let me turn off the live stream. I don't think it's necessary to be live streamed. Okay, we are on the record in the matter of the Ball minors. Mr. Way is here for the petitioner. Margaret Parks for the agency. Mr. Brown is LGAL. Ms. McCluskey represents the mother, who I believe is present. Ma'am, can you hear me?
All right.
Yes,
I'm
I can.
try to help. Brittany's got the.
Okay. Okay, Mr. Ball is present. And let me just say a word to Mr. Riddle and get him on his way. Mr. Riddle, can you? Okay, pardon that. So we've run into a snag with my personal schedule today. My apologies to everyone, but I've got to leave early today for an appointment. What we decided to do informally this morning was to find a date off my normal neglect day so that we can devote full attention to this case without having to wait for other matters to get addressed. The date we found is Friday, March 19th at 2 p.m. And I would not anticipate anything interfering with that date. Is that date a problem for anyone?
It is for us.
No.
We have Solomon that day.
Oh, that's going away.
Oh, then it's not.
I would like to address the court if I may.
You may, sir. Go right ahead.
So I would like to motion for an in-person hearing. I would also like to motion for a jury trial, as I was unaware that I was ever able to. No one had informed me that I was able to have a jury trial. And in regards to parenting time, I do not wish to see my children behind a face mask in a building. So I was hoping to be able to meet them at Cascades Park or something out in the open, you know, so that they could have fresh air and we could have family time. With all due respect to the court, I just don't feel as though I'm gonna have a fair bench trial. And I hate to ask the judge to recuse himself, just primarily for facts to substantiate is that I was not included on 3 different hearings that you guys had, which makes it apparent that I'm not on the same scope as you with the personal relationships you have in the office with my opposition counsel. So I feel as though to have a bench trial with you would give me a great disadvantage. So I would like to motion for an administrative hearing by a different judge. And that is all I have, Your Honor.
So, well, let's address the parenting time first. I know at least for a time, the agency was doing, when the weather was good, was doing some visits outside. Is it possible for Mr. Ball, assuming the weather's good, to have an outdoor visit with his children?
That he sees.
Yeah, I don't think that there would be any issue with that. The weather's nice. I'm sure he can connect with Miss Vader and schedule that.
But that
And I know obviously we've got good weather today. Have you had a set day when you see your children, Mr. Ball?
Your Honor, I actually have an appointment for tomorrow morning at 9 a.m. till 10 a.m. So that's the first one. It'd be awesome if I could just see him outside. The personal connection isn't the same, with the mask on and all the, I'd hate to see them for the first time in the mask, that's all.
So assuming we've got good weather in the morning, if you could, Ms. Parks, pass that on to the foster care worker
Yep, I
and
can
try to
absolutely do that.
accommodate Mr. Ball. Thank you. Secondly, let's address your request that I recuse myself. Why do you think I need to recuse myself from this case, Mr. Ball?
Well, Your Honor, on the 29th, I was totally unaware of what I was up against. And no one gave me any direction as to the fact that I could have a jury trial. So that was something that I feel as though was a personal thing. But on the second, as far as you muted and yelled at Courtney Ball, which to me is a personal thing when you mute someone and yell at someone in the courtroom in front of everyone. March 2nd, you guys had a meeting without me there, without me present, and adjourned the trial and put nothing on record, which means I was not included in the conversation. I am at this point counsel. So for you to disclude me in the conversation is kind of partial towards the opposition counsel. So I should have been present at that at that meeting. Today, you guys had a meeting, a personal private meeting without me. So not saying intentionally anyone is doing anything, but in my eyes, I have an unfair advantage when you guys all sit around and talk together and I'm not included in the conversation. So I just would like to try to make sure that I have a fair shot at this trial, because my personal relationship isn't as great with you guys. I would hope that I haven't swayed your opinion just because I've mismanaged my emotions in the beginning, but in no way do I feel safe going to a bench trial, knowing what I know as of today. So that's what I have to say.
I'm pulling up something on my calendar. Just give me a second. So I'm not sure what you're referring to on the 2nd. I know the case was scheduled last for a bench trial on that date. I mean, occasionally I do have conversations with counsel about scheduling matters just to make sure that dates work for everyone. But we don't have conversations outside of your presence about anything other than scheduling matters that are not on the record.
Well, what if I have an objection to the scheduling? I'm going out on a limb here, sir. I apologize. I'm counsel now, so I should be a part of all counsel conversation. There's a lot going on behind the scenes right now that you don't know about. I get that. But I'm worried.
You know, I'm worried, and I don't even, to be honest with you, sir, I don't even know what I'm going to lose if I lose. Still to this day, I do not know exactly what will happen if I don't win. So with that being said, I just feel as though the personal relationship in your office, I would like an in-person hearing so that you know, I could be in the courtroom, the same courtroom that you people are in, so that I could have that same, you know, advantage. I would like a jury trial so that I could have a jury of my peers that may have kids, that may understand, that may read between the lines to help me out. I feel as though everyone on council has already made you have an opinion of myself, with also myself included, because I wasn't acting appropriately when I was, you know, stressing because these are my kids. So I had to reevaluate myself and become a better person real quick. Okay. And so I know I'm not perfect. I still have some things to do, but, you know, I'm not a lawyer. You know, I'm just trying to figure this out and just make sure that I have the best opportunity to be heard and to have my children have the best outcome that they can have. Because up until this time, sir, I mean, I have 50-some recordings. Nothing has been being said about my children, and that's the main focus. So the longer I'm out of the house, the worse. You know, it's been long enough. Please send me home. That's all I'm saying. So.
Well, regarding your request to participate in person, I can grant that request. That's not a problem. With respect to a jury, the only way you could get a jury trial at this point is if I agree to waive the timelines. You were advised at the very first hearing you attended of your right to a jury trial.
No, sir, I was not, sir. And I have it on recording, sir. I actually have that. I have that hearing on recording, sir. On the 29th, I have it recorded. No one ever once told me that I had the right to a jury trial. Not once in the recordings, sir. And so then then Ken, you know, he quit on me after that. Then Tim quit on me after that. I have recordings talking to your secretary that I've been asking her about a jury trial. I have many recordings, sir. I've been asking for help from everybody around you since this thing began. And I've been being treated like the scum of the earth because I have a record and because people have lied on me in the past. I have made mistakes. I'm not perfect, but I have changed who I am as a person. And that's all that matters to me. And that's what God's going to see this through. And I'm going to see it through to the end. I'm going to go through appeals. I'm going to do everything that I have to do to make sure that everybody is held accountable for what we're doing today.
So I will personally go back and listen to the initial hearing at which you participated. I know I informed everyone at that first preliminary hearing of their right to a jury trial.
Well, Your Honor, maybe you didn't intentionally do it. You didn't intentionally do it, Your Honor. Like, I'm not trying to attack the court. Please know this. I'm just trying to have a fair. I just listened to it an hour ago.
What I'm going to do is go back. Your first hearing typically is in front of a referee. I know the referees go through that information. When it's in front of me, I go through that information, but I will take the time to go back and listen to see if I somehow missed what I routinely do at every hearing. And if I missed it, I may decide to grant you a jury trial. Sir, you need to understand, it's hard enough for a person who's not a lawyer to do a bench trial, but I can grant a lot of latitude, and I typically do when I have non-lawyers who are trying cases. I can't do that when we're in front of a jury. I cannot give the jury any indication that I am helping one person or another person at a trial. In a jury trial, you are completely on your own. If you want a jury trial and I'm satisfied that you're right, that I didn't properly inform you of a jury trial, I'll give you a jury trial. I don't think you realize what you're asking for, sir. But in any event, with respect to your request for recusal, I'm going to deny that. I don't think you've articulated a basis that would justify me stepping off this case and handing it to another judge. With respect to an in-person trial, I've already told you, you do have a right to that. We have set aside March 19th, the afternoon, for a bench trial. Between now and then, I'll have a chance to consider your request for a jury trial. If I decide to grant that, we'll, I don't know when that will be. We're not allowed to do jury trials currently. The soonest I would anticipate that you could see a trial, if I grant you the request and you continue to insist on it, is probably sometime in the fall when things have returned to normal. Right now, I can't bring a jury into my courtroom. I don't have a place for them to deliberate. I don't have a place to bring them in and out of the courtroom. If I decide to grant you a jury and you continue to insist on it, I don't know when that's going to be, sir. I can only guess, maybe in the fall. I can give you a speedy bench trial on the 19th, and you can participate in person in that. We can make arrangements to allow you in the courtroom. You have to follow all the protocol for the COVID-19, but you could be present in the courtroom.
Okay.
So
Well,
for now, I
would like to motion to dismiss based on misconduct, on ethical misconduct.
All right, well, I can rule on that motion. That motion's denied. There hasn't been any unethical conduct. We'll go ahead and move forward with the trial, as I indicated, at 2 o'clock on the 19th. You and anyone else who wants to participate in person may do so. Whoever would prefer to participate by Zoom, they can do that. In the meantime, I'm going to consider your request for a jury trial by going back and listening to see whether or not what you're reporting to me is accurate.
Thank you, Your Honor.
I would ask also that you listen to Referee Bates' testimony or her hearing, because this wasn't a removal. So I don't know if you went through whether we actually did a preliminary hearing in this matter.
Well, I'll listen to each of the initial hearings.
Thank you, Your Honor.
I would also ask that Mr. Ball quit recording conversations in violation of the Michigan Criminal Code of Conduct. Doing that is illegal, and we will consider that kind of charge. So I'm just letting you know right now.
All right. Thank you. We'll see you back.
Thank you.
We'll see you back here on the 19th, 2 o'clock. So we're on the record in the Ball matter. Shannon, can you see everybody that's here? Both mom and dad are present.
Yeah, I can.
Okay.
I got it.
All right, good. So this was a hearing that was scheduled at the request of the agency. What's the specific request, Ms. Tucker?
Yes, Your Honor. At the last parenting time last week, the parents were scheduled for a 2-hour visit at Cascades Park. Unfortunately, Mr. Ball in particular got very aggressive and hostile with the 2 workers who were present, Ms. Fader and Mr. Davis, to the point where he was using insults and offensive language with Ms. Fader. He was getting into the personal space of Mr. Davis to the point where Ms. Fader thought that she would have to call 911 if Mr. Ball was to continue to assault Mr. Davis. Ms. Fader can certainly give more details as to that, but the children were present throughout the entire interaction. And it just turned into a very hostile, very uncomfortable, and very inappropriate situation very quickly. It ended with Mr. Ball leaving the park and Miss Ball, or Courtney leaving the park shortly thereafter. This has been spoken to, or this has been relayed to me through the workers, and Miss Carafino was also informed of this incident. Given the nature of the situation and the safety concerns for all involved, the agency would request that the visitations be supervised or set up in a place where we can ensure the safety of all parties. At this point, Mr. Ball has shown time and time again that he just cannot conduct himself in a way that is conducive to the safety and appropriateness necessary to be around his children and to, frankly, even interact with DHHS. So that is a huge concern for the agency, and we want to do whatever we can to, keep at least the children away from this behavior, as well as to ensure the safety of our workers.
Mr. Ball, do you care to respond?
Oh, yes, I do, sir. Everyone was leaving the park, okay? So Miss Fader and Mr. Chris were talking about me doing some family first, okay? So Courtney's telling me everything they're saying. So I asked them if they had anything to talk to me about. They said they do not have anything to talk to me about. Well, how am I going home? Okay, so my children were in the truck. There was no kids around. This is why I record everything, because they try to lie and say that things happen that didn't say. It didn't happen, okay? Now, yes, I get frustrated. I do understand that. Miss Judy, the lady that's been in our house every day, 5 days a week, said there's no domestic violence that's ongoing. There's no signs of physical abuse. There's no signs of anything, okay? She said, Miss Louder, Shannon Louder said I should be at home, okay? My kids cry every time I walk out the door. So they had me going 5 days a week to 1 day. How is that any kind of progression, okay? Nothing has been proven. There's nothing been proven of nothing.
Mr. Ball, Mr. Ball, let me stop you.
Yes, sir.
We're not here to try your case today.
But
we're here to find out about what happened at this visit. The agency's telling me hold on.
Okay, yes, sir.
How they perceived your behavior that day. I want you to address that and that only.
Okay, so I asked Chris if we had anything to talk about because they wanted me to do work family first. Amber, which I asked not to even, she hasn't been coming to any visits. Amber is very rude to me. She's been rude to me. That's why I record everything, but I didn't record this, you see? So now I'm in a dilemma. So Amber's laughing at me. Do we have anything to talk about, Chris and Amber? No, we don't have anything to talk about. But Courtney just had a whole bunch of stuff that they was telling her, and we are our family. This is my kids. So now you're making it so I can't even be a part of the conversation. So she's laughing at me in my face, snickering, smiling at me, laughing at me. So yes, I got irritated. I don't even want her at my visits. My kids there's no, this is just crazy, man. There's no proof of any domestic violence ongoing or any physical anything. There's nothing. So why are we still here? Why are we still here? Judy said that everything's good.
We do, Mr. Ball. You've demanded a jury trial.
Oh, for sure.
That's where I get proof of whatever it is that the agency has as a basis for me to take jurisdiction over your children. That happens at a trial. We haven't had a trial yet.
I get that. But you know why they want to come to court today? So now they're coming, oh, well, he was doing this and that, but they want to come to court today so they can they want to further give my children trauma, mental trauma. They've already said there's no domestic violence. There's no proof of any, abuse. So why are we still having this conversation? The way I treat.
And also, as mother, could I speak for just a quick second?
Hold on a minute.
I'm on. Okay.
I want to make sure Mr. Ball is done.
Your Honor, I did not assault anyone. I did not do anything. I was in arm's length of everyone. Okay. That's it. I just told them I don't like how they're handling my situation, and I'm getting the hell out of here. And I left. And they were already leaving because it was cold outside. It was too windy.
Mr. Ball, do you realize that that kind of a conversation isn't appropriate at a parenting time visit?
Sir, we didn't have any. They were having the conversation with Courtney. So why didn't they have it with me?
Your visit is for you to see your kids, not to get into arguments with the workers about how they're handling your case. Those are totally separate issues.
Everyone was leaving, sir. I was just talking to them at the end of it. My wife was leaving because it was too cold. Okay, sir. It wasn't they didn't have to stop the visit. We already stopped the visit. We said we're leaving. I put my kids in the car. My kids were in the truck. They were nowhere near any conversation we had. Okay, so I am getting frustrated, Your Honor, because I keep getting.
All right, let me hear from the mother.
So what happened is we were leaving because it was cold. They had a conversation with me, Judy, Chris, and Amber, but we were leaving. My kids were in the car. And what happened between them, my kids had no idea. They didn't hear nothing. He walked over away from them to talk to Amber and Chris, and then he walked back. She ended it. We were already leaving anyway. She said that he said some stuff. I went to my car. He went to his car. My kids saw nothing, heard nothing. There was no any kind of altercation. No one even in the park probably even looked over at them. That is insane. So that's too much for them to say that. Now, if he was disrespectful, that's on him. But I'm telling you, my children heard nothing.
Your Honor, I guess I would ask that Ms. Fader be able to verbalize her side of the story. I wasn't there. She would be able to provide more details as to what occurred.
Like you were there, though. You were talking like you were there.
Hold on.
This is crazy.
Mr. Ball, it's not your turn to talk. Ms. Fader, yes. I'd like to hear your observations of what happened on that occasion.
Yeah.
First of all, where were you? Where was this?
We were at Cascades Park on Wednesday last week. Because of COVID, Russ did not want to do visits at our office, so we have accommodated his request, and we have allowed visits to occur outside at Cascades. Due to the interactions between Russ and I and our difficulty of seeing eye to eye, we have assigned 2 workers to the case, myself to work with Courtney and the children, and Chris Davis to work with Russ. So during the visits, both workers have been present. And this day specifically, I met with Courtney along with the family's first worker off to the side while Russ was with his children and being supervised by Chris. Following that, Courtney joined the visit and played with the kids and had ice cream and enjoyed that. About an hour into it, Russ walked over to Chris and myself, asked if we needed to speak with him. And because it was a visit and Chris is his worker, we said no. He then asked about court and whether or not the FTM that we need to schedule is the same thing. We informed him that it was separate. It was at that point he started degrading me, calling me names, and getting very, in his term, frustrated with us. And started walking away. Once he started calling me names and degrading me, Chris and I both agreed that the visit needed to end. I had walked over to Courtney, informed her that the visit needed to end. She had asked why, and she started gathering the kids to go. Russ was in the background yelling at her, "Don't fucking talk to them, get the kids in the fucking car." So as Courtney's getting the children in the car, that is when he, with his arms spread open, started approaching Chris Davis and becoming belligerent towards them as well.
So the statement Mr. Ball made and the mother made that the children were in the car and couldn't hear any of this is incorrect.
I believe so, yes.
That's why I record everything, because you people
Amber,
lie.
you know for a fact the children were in the car. Amber, you're the one that came to me and said that he called me a fat ass. We have to end it. You know my kids were in the car. Reagan was already in the car because it was freezing.
Courtney was
Lying,
putting
bro.
kids
That's
in
why
the car. It
everything.
is very possible
That's
that
why I
they
record
Here's-
everything, because you people are lying. You're fucking lying. And I don't even care. If you don't want me to be a part of my kid's life, cool. My kids are
So here's what I'm going to do. I'm ordering visits supervised at the agency going forward.
Judge, may I address something just real briefly?
Go ahead, Mr. Brown.
I'm the guardian. You know, I was going to call, and maybe cooler heads can prevail. I was going to call Mr. Ball as his children's attorney, since he does not have an attorney. And that's what I think is a shame in this right now, that there couldn't be any common ground to help him with realizing the situation in this case. This case could have been potentially over by now. Mr. Hotchkiss is the nicest attorney that, and a good attorney. So I can't believe that somebody can't get along with Mr. Hotchkiss. And Mr. Williams is a competent attorney. That asking for a jury trial, this case could go into next year. And if we could maybe appoint somebody, maybe not appoint him, but just to talk to Mr. Ball and let him know that this case could have been getting ready to close by now. But all the disinformation going around, because Mr. Ball can't navigate this system by himself, is just causing a mess. And it's probably causing hardship on the children, and it'll continue to cause hardship on the children because of lack of information in this case. I can't advise him, but again, this case could have been nearing its end by now if people could have just listened to one another.
Yes, I agree completely. My kids are suffering tremendously not having him home.
And that's his fault right now. All they want to do is talk to him, and they couldn't even talk to your husband.
Your Honor, I do have one other issue to bring up besides just a visit at the park whenever the court is ready.
Go ahead, Ms. Tucker.
Okay, Your Honor, another issue in this case has been DHHS's ability to interview the children. And the parents continue to deny access to the children in that regard. And so part of the reason that they need to interview the children alone is because we would like to have the kids assessed at the CTAC Center. And the CTAC Center would prefer to have some idea of what the kids would say before they perform their assessment. So we would ask that the court order that DHHS be allowed to interview the children alone outside of the presence of the parents. And we also would like to court order the CTAC assessment.
Could somebody let me know why someone would think a CTAC assessment? I haven't been apprised of this. Why in the world that would be necessary in a situation like this? Because they have been interviewed. Just give me some idea why something so drastic as a CTAC would be needed for these children. I would just, you can email me. I'd just like to know what the basis for that is as their guardian.
I would too, as their mother.
So Ms. Tucker, Ms. Tucker,
Yes, Your Honor.
you're telling me these children have never been interviewed by CPS?
I would defer to Ms. Parks or Ms. Fader. That is my understanding, is that they have continually been denied access or have not been allowed to speak with the children in a setting that the children may feel safe to disclose what is actually occurring in the home.
I can speak to that.
Your Honor, that is completely false, Your Honor.
Hold on. So Ms. Parks, can you speak to that?
I can, Your Honor. During my investigation, so this was in December, Ms. Ball allowed me to speak with the children. I spoke with all of the children in the same room as her. There was also a camera in the room. So it was, well, I did speak with them. It was extremely chaotic. I had all of the kids, plus a parent, plus a camera in the room. The quality of if you would call it an interview, was extremely poor. And so that's why we had requested individual interviews that are private without a parent being there, and obviously no, not a camera in that setting.
Sir, that's a nanny cam for my babysitters. I can have a camera anywhere in my house. Why can't a camera be there for them to interview my children? That's insane.
Okay, I can speak to that as well because I was part of that conversation. Ms. Ball, I've got that. It was my recollection that Ms. Ball expressed some concerns with the children being interviewed alone. And I was under the impression we'd come to the resolution that the interviews would be recorded, that Ms. Ball would not be present, but that we could review the interviews after the fact.
Yes, I agree with that. Why haven't you set that up yet?
Right, so we did resolve that quite some time ago. I'm not sure why that's not happening.
We had offered to schedule to do the interviews, the initial interview at least, at the Child Advocacy Center. I contacted law enforcement and the CAC. They were both on board. Ms. Bader can probably speak to this more than myself because I wasn't part of that conversation, but my understanding is that when that was proposed to the parents, they declined again.
Yeah, that is correct. So Chris Davis and I both spoke with Ross and Courtney. They requested, instead of the CAC doing the interview, that Chris Davis complete that. They signed a service agreement to allow that to happen. Courtney, I believe, is still on board with allowing that interview to occur. However, Ross has said no, absolutely not. Not as long as myself is on the case.
So if there were a CAC interview, obviously we know the format for that. It's fully recorded. There's a complete record made of the of what happened. It's outside of the presence of any parent. There's no reason why that shouldn't happen. If the children truly aren't afraid of their father or afraid of their mother, and I'm assuming when they speak in a CAC setting, they will honestly say how they feel and how they think, and there will be a complete record of it. What possible objection to that does either parent have? I don't understand.
I have no objection to it. I would like it done as soon as possible so my husband can come home. And I've said this since day one.
Well, let's do it. Let's do it. I mean, this is easy. Let's just get it done.
Yeah, I think the issue was Mr. Ball objecting. So if the court is willing to put that in their order, that would be
I'm going to order. I'm going to order CAC interviews under CAC rules. All right, now Mr. Ball wants to speak. I'm going to unmute him briefly.
I understand what's going on right here. The only objection, my kids are going to say, I'm not worried about what my kids are going to say. Why do we keep putting my kids through mental stress? Okay. They already said there was a woman in our house 2 hours every day, 5 days a week for 28 days. She said there's no signs of any domestic violence ongoing or any physical abuse. So why, if my kids are okay, so I do the psych and it's good. So now they want to go to this. So they're trying to just get something. Why do my kids have to have mental stress put on them continually when there's evidence that I haven't done it, that my kids are fine. I don't understand why you guys keep doing this. This is what I'm saying. And nobody likes me.
I'm going to order CAC. I'm going to order CAC interviews for each child, and then I want to see the reports of those as soon as they're done.
They don't do reports.
If my kids aren't being recorded and we can't know what's going on, my kids aren't.
Well, they will be, Mr. Ball, they will be recorded. These interviews are recorded.
And they've already talked to my kids 3 or 4 different times. Man. So now they can't find anything. So now they're trying to do something else. That's all this boils down to. They've already done all these tests, done these conversations. And the kids are fine.
Mr. Ball, if what you're saying is correct, then that's what will result from a CAC interview.
And that's fine, but how about in the long term, sir? How about the long term? How about PTSD? How about going and getting interrogated by people for nothing? There's not one accusation of anything that I've done to my kids.
Mr. Ball, they're not interrogations. They are not
That's
interrogations.
exactly what it is, man. If you put your kids in a room, have some person that they don't even know talking to them, what is that?
I know what an interrogation is. They're not interrogations. All right, I'm going to order the CAC interviews.
Your Honor.
I'm going to be suing you
I'm ordering that the visits be
I would
moved.
suggest that you recuse yourself, right?
I'm going to order that the visits with Dad be supervised at the agency. I do want to move this forward. So Mr. Ball is pretty adamant that there's been people in the home, they've observed, they haven't seen any evidence of domestic violence. I mean, I want to give him his day in court, but he's demanded a jury trial, so I can't really do that until we're able to do a jury trial. But at least I can deal with these two issues. Do we have something else on the calendar right now, Shannon?
For this case, or?
For this case, yeah.
Your Honor, this is Farah speaking. Can I speak for a second?
Wait a minute. I'm trying to get some information from Shannon.
We've got a pretrial scheduled for June 8th at 8:30.
Okay. So we've got a pretrial on June 8th, and hopefully we'll know better by then when I can do a jury trial. So go ahead, Ms. Galamali.
So we would also have to have it ordered that the parents not transport the kids to the CAC because they're both listed as perpetrators. They would not be able to transport the children. So somebody else would have to transport the kids.
Oh, I don't have anybody else to transport our children, and my kids will not go with just anybody. It's
Your
gonna be hard
Hold
for them to them away right now.
on, ma'am. Hold on. So, Ms. Galamali, I guess I'm trying to understand. The children are in the mother's care and custody. What's the problem with her transporting them?
Due to the, oh, sorry, Kaylee, go ahead.
That's okay. It's a CAC policy that the subjects that the children are being interviewed about, so in this case, it would be the mom and the dad, they are not allowed to transport the kids to the CAC. It's just another precaution so that the kids are more comfortable talking about potential issues in the home. It's a very standard procedural rule at the CAC that the subjects that the kids are being interviewed about are not allowed to be there. So in situations like this, we've had CPS transport in the past. We've also had law enforcement transport if the parents, for whatever reason, absolutely object to CPS or DHHS being the ones to transport. I've never had an issue having DHS transport or the law enforcement agency transport. It's really just another precaution for the kids to be comfortable in saying whatever they need to say.
Is it possible that they could be transported by a friend or family member and that would satisfy the CAC rules?
Yes, it would. As long as Courtney and Mr. Ball are not on the premises, whoever's willing to transport is fine to bring them.
All right, let me ask Mom about that.
I have
So,
nobody to
ma'am-
transport. I'm sorry, I have no support besides my husband. I have nobody to transport my children there.
So there's not a friend or a relative?
She lives
or-
in Indiana, sir. I have nobody. And the fact that you would even have my kids riding a police car or with a caseworker is traumatic. Again, going back to what Ross is saying, this is crazy. This can't
Ma'am,
be part of the
ma'am,
rules. Oh, you can't interview
ma'am.
my kids unless I go drop them off? Come on.
Ma'am, listen to me, okay? I'm trying to avoid a police car. I was exploring with you. I mean, you don't have anyone in this area that your children know that you would be comfortable with giving them a ride over there and bringing them back so that they're not in a police car or something else.
I have one person. She lives in Fort Wayne, Indiana, and she is a stenographer at a hospital. She's very busy. That's the only person my kids will go with. I mean, that's the only person I could think of right now at the top of my head. Again, this is pushing us back and back and back and back and back. It's like my kids need their dad.
All right, well, I'm trying very much, ma'am, to accommodate both your
You are. I
concerns
appreciate it.
and the agency's concerns for the policies of this center. Can you talk to this friend and see if
we can get a date, then I can definitely talk to her. Yes.
let's try that before we do anything else. I want to respect your concerns, ma'am, but I also want the kids interviewed in a setting that, I mean, you should expect fully that the kids are going to say what you expect them to say. So what's to be afraid of?
Yeah, I'm not afraid of anything. I just think it's crazy that I can't drive them there. But I mean, again, it's just another hassle for me to have to go through, as I've done nothing, but it's fine. I will find a way for my kids to get there. Yes.
All right. So Callie, if you could identify a date, you could communicate that to her so that she can have the friend do the transport. That way the children aren't in any way traumatized.
Yes.
Somebody they know.
Yes.
Let's do it that way.
Maybe
Mr. Ball, that's not going to win you any points. You're just demonstrating to me, sir, why there are concerns here. You're a rageaholic. You're out of control. All right, we'll put this in the order. Let's get this done.
Thank you, Your Honor.
Okay, Shannon, put us on the record, please.
Okay.
All right, this is the matter of the Ball minors. Sorry to keep you all waiting so long. We were tied up with another off-the-record case that we were all trying to figure out some seldom used court rules and figure out how to go. They asked me to call this case first because we didn't think it would take quite as long. So for the record, we have Kelly Tucker representing the petitioner on behalf of the agency, Damian Brining and Sean Furlong. And let's see, Mr. Brown is LGAL. And I forgot who represents Mom.
That's me, Your Honor, Rebecca.
All right, I'm going to write that in the jacket so I don't have to remember. Mom is present by phone. And Father's present in the hearing, and I think that's everybody. So we're having another pretrial today. Trying to figure out how soon we can actually do a jury trial. I'm hearing that, well, maybe you can tell me for sure, Callie, is Judge Jordan doing a jury trial this week?
Not that I have heard.
I just heard a rumor that she was scheduled to do one soon. I wasn't sure if it was this week or not.
I don't think it's this week. Last I heard, but again, I'm kind of out of the criminal world at this point, is still looking at July to start them.
All right. And I don't know what our restrictions are going to look like in July. Things are supposed to open up considerably more than they are now. I guess the best I can do is maybe set another pretrial, our first available Tuesday in July. Certainly by then, I think I'll be able to set a trial date with some confidence. So Mr. Ball, we've talked in the past about the complexities of doing a trial, being a non-lawyer, but particularly a jury trial. I think one possibility that I haven't broached with any of the attorneys yet is, although you're going to be representing yourself at a trial, I think it's possible that I could appoint an attorney whose sole job is to assist you during a trial. You would still conduct your own trial, but that attorney would be available if you had questions about the procedure as you go along. Is that something you'd be interested in?
Yes, sir. Definitely.
And I can't remember who the last one I appointed was. Was that you, Mr. Hotchkiss?
Tim Williams.
He's going through health problems right now, so I don't know when he's going to be available.
Okay.
Let me ask, Mr. Hotchkiss, I don't know if you're listening in now or not. I know you're muted.
Your Honor, I previously had been appointed and there would have been a breakdown of the relationship and you relieved me of that appointment.
Right, I understand that. What I'm wondering about is if Mr. Ball proceeds to represent himself and doesn't hire any other counsel, do you believe you could be present simply to assist him in any questions he might have about the process? You wouldn't be required to prepare. You wouldn't be required to present. All you'd be there is, and I know judges do this in criminal trials when criminal defendants insist on representing themselves. So even though you and Mr. Ball would disagree on legal strategy, he gets to use his own strategy. He gets to do it as he wants, but would have someone available if he has a question about procedure. Is that something that you believe, a role that you could fill?
I have no objection to that, Your Honor. I guess I'd leave that to Mr. Ball.
I agree to it. That's fine with me.
Mr. Hotchkiss is a very skilled, experienced attorney. I think he would be of great assistance to you just for some of the procedural stuff. You could have a conversation with him throughout when you had questions about something, but you get to proceed. You're driving the bus. He's just there to help you.
Yes, sir.
All right.
If I had money though, if I had money, I would have got a lawyer, but I don't have enough money anymore. So.
All right. I feel better about that than just turning you loose on a jury without the kind of practical experience.
I appreciate that. That's definitely a help. Could I address the court for 2 seconds?
Just a second. Callie, was there anything else you wanted to bring up today, or any other attorney?
Yes.
I don't, Your Honor. Sorry, Ivan.
All right. And Mr. Brown, let me ask you, first of all, how are Mr. Ball's children doing?
Judge, I haven't had any communication. We haven't adjudicated yet. I haven't had any direct conversations with them. They're quite young. I'm just relying on what the worker says, that everything is going well with them.
All right. And you wanted to address the court. Go ahead.
Yes. Briefly, the court is taking care of partially what I was going to request regarding the attorney. You kind of preempted me there. Mr. Ball and I have had some email conversations regarding this case, and I think he's been receptive to what I have said. And I'm sure the court knows that I was quite direct in what I said to Mr. Ball, and he seemed receptive to what I have said to him. What's kind of troubled me in this case is because some of the actions that have occurred, this case could have been over by now. Take a couple classes, do what you're supposed to do, return home. This case could have been over instead of languishing. And that troubles me. And I think Mr. Ball may realize that at this point. I hope he does. I was going to ask the court to give it one more try with an attorney to see if Mr. Ball can be talked to. I hate this case languishing when it should be over by now. And Mr. Ball back in the home, if he had accepted or listened to Mr. Hotchkiss. Mr. Ball indicates he would hire an attorney if he had the money. Well, you know, you're getting Mr. Hotchkiss, who many people would seek out for free. trust what he says. Mr. Hotchkiss is, if I were going through something, I would hire Mr. Hotchkiss. So I'm just begging you to do that for your children's sake. Thank you.
So I've reappointed Mr. Hotchkiss in the limited role, but that doesn't keep Mr. Ball from seeking advice from him, even as to the merits. I would encourage those conversations. In the meantime, since we still have a jury demand, I can't schedule a jury trial yet. I'm very hopeful that at least when we come back in July, what's our first available Tuesday in July, Shannon?
13th.
July 13th. And hopefully by then, at a minimum, I will be able to tell you with certainty when this jury trial can occur. I think we'll know a lot more then, and I'm optimistic that things are going to move pretty quickly and in reopening. But in the meantime, Mr. Ball, I would encourage you to seek out Mr. Hotchkiss. Like I say, he's appointed in a limited role. You don't have to take his advice. And he's not conflicted in the sense that he knows you're driving the bus and you ultimately get to make the shots. He's just there to provide advice and guidance.
Well, thank you, sir.
Mr. Ball, is your number still 734?
Yes, sir.
Okay. Do you mind if I call you maybe sometime this week or next week to discuss this?
That would be awesome. Thank you.
Okay. I will give you a call.
Go ahead, Mr. Ball.
I definitely have been approaching everything wrong. I just miss my kids. So, and I am still taking counseling. I've taken all the classes. I'm doing everything they want me to do. I have counseling later today at 4. I was going to ask that, I know I can't go home. Obviously, that's the conversation we're having. So my daughter is graduating tomorrow at 10 a.m. from elementary school, and I would like to go. I'd like to start seeing them way more often. I don't know what we could do about that now, but there's no danger to my kids. I just sitting there now that they've interviewed them, everybody's talked, and I just would like to see my kids. But at the least, I'd like to be able to go to her graduation in the morning.
I have no objection to that.
Just 1 second. Can I just speak for just a second? It's been 6 months without him. And if we could just get unsupervised visits, that would be huge, because they are the only ones that are hurting. No one else is suffering in this case at all but my kids. So if we could please, we had the interviews, we've done everything. If we could please at least get unsupervised visits so he can pick his children up and help me and we can start to rebuild our family, please.
Well, let's take the first request, which is attending the graduation. Is anyone have an objection to Mr. Ball attending his child's graduation?
Mr. Furlong, do you have any thoughts on that? I don't have an objection if Mr. Furlong is comfortable with that.
Good morning, Your Honor. I've been informed that he can go to it, but I would have to supervise, since it's still supervised parenting time, so I'd have to sit in the back.
We've got a crowd of people there. Is there really a need? I can certainly order that he be allowed to attend the graduation and that CPS has no obligation to supervise the graduation. The unsupervised parenting time beyond that is a different issue. And before I wade into that, I want to address this. He's going to be at a school event. There's going to be other parents there. In that setting, I guess I don't see any danger.
That'd be at your discretion, Your Honor.
All right, Mr. Ball, you can attend your child's graduation.
Thank you.
With respect to beginning unsupervised parenting time, my inclination, Mr. Ball, you've indicated that you've been taking some classes and getting some services. Has that been verified by anyone from the agency, Mr. Furlong or Mr. Brining?
I've tried to reach his counselor, Miss Cheesebro, with no success. She will not return faxes that I've sent her for a release, voicemails. She's likely working out of the office. I've requested per my own group of coworkers for email for her and trying to get in contact with her just to verify how it's going and to verify whether or not she's received a copy of the psychological evaluation so that her services with Mr. Ball can be based off the recommendations from Ms. Louder.
So, Mr. Ball, is that the counselor who you're seeing?
Ashley Cheesebro, yes.
If you could, I want to get some independent feedback before I say unsupervised visits can begin. Okay. If we can get some verification from your counselor as to what exactly she's counseling you for, and are you making progress? I would be far more receptive to entertaining unsupervised visits, but I need something other than just you or your wife saying, we think it'll be okay. I mean, I need the agency to be able to look at the situation. Could you encourage your counselor, please, to respond to Mr. Furlong?
Yes, sir. I'm actually emailing her now, and at the very latest tonight when I have my session, I will tell her what needs to be done.
Sign a release.
Sign a release so that she can talk to Mr. Furlong, and we don't have to wait until July 13th. Mr. Furlong, if you've got information to suggest that we could commence some level of unsupervised visits, I would certainly be willing to entertain an early review before this next pretrial date.
Yes, Your Honor.
Your Honor, for what it's worth, I just want to make it clear on the record. The court's order is going to specify that Mr. Ball can attend the graduation, but any other contact with his children shall remain supervised, correct?
Right. He can certainly have contact with his children at this graduation, but when the graduation is over, they need to go their separate ways.
Thank you.
And then we'll revisit the issue of visits at a future date, certainly no later than July 13th, but even sooner if someone asks for an earlier hearing. Okay, so you're welcome. July 13th at 8:30?
If that's when you want to hold the pretrial, yes.
Yeah, July 13th at 8:30. Thank you, everyone.
Thank you.
Have a great day.
You're welcome, ma'am.
Thank you.
You too.